Hey, good afternoon, everyone. You're in the right spot for today's webinar. We are going to give people for a couple more minutes after the hour, as we usually do, and then we'll go ahead and get started. So we'll be getting going here in about 2 or 3 minutes. Thanks. All right, everyone, we're about 3 minutes after the hour, so we'll go ahead and at least get started on the housekeeping. As usual, we have muted all incoming lines to help us get a good recording going today. This will be recorded, and you will get a copy of both the recording and the slides sent to you following today's webinar. If you're registered, we'll also post those on the MSHA Defense Report blog, so you can find them there. And if you don't get a copy of your recording or slides, just let us know. We'll make sure we get it over to you. To the extent there are questions, we welcome those throughout the presentation, and at the close, you can ask those by submitting a chat in the chat function. Now, we will be monitoring that throughout the webinar today. We will answer what questions we can and as it makes sense during the webinar itself. And then anything that we did not get to at that point, we will answer at the close, with one caveat that if it is a very fact-specific or kind of complex question, we might follow up with you directly afterwards just to make sure we're getting all the information involved and getting you the right answer. So with that, we'll take a quick pause here, make sure the recording is going, and get started. All right, good afternoon, everybody, and thank you for joining us for today's webinar in the MSHA Defense Report webinar series, Preparing for MSHA Serious Incident Investigation. Today is going to be one of those presentations and discussions that we hope we don't have to worry about. And that's because we're hoping we never have to have a serious incident in our site or worry about MSHA investigating one. Before we get into that, though, just for those who have not joined us, welcome. My name is Nick Scala. I'll be your presenter today. I am the chair of the National MSHA Practice Group at Conn Maciel Carey. I'm also a partner in the OSHA Practice Group, so we can cover you both on the mine site and when you're venturing off of it. But in that, represent companies dealing in all phases of involvement with MSHA, whether the investigation side, challenging citations, litigating them before the Federal Mine Safety and Health Review Commission. And then a large part of what we do is help companies, help operators, production operators, independent contractors, navigate the challenging environment of serious incident, fatality investigations, and special investigations, whether that's for 110 proceedings following serious enforcement into agents of the company, or we're talking about 105 investigations into claims or complaints of discrimination or interference in minors' rights. So, this is something we're well versed in. We hope to give you a good base today to kind of prepare yourself and prepare your operations and your company to, put your best foot forward in the event that you do have a situation that requires prompt attention or immediate attention in terms of a serious incident investigation. But we are here to be a reference for you, not just today, but throughout that process. So I welcome, any questions we have, and then as we get going, we'll be able to dive into things a bit further. But if you ever are undergoing one of these investigations or have a accident or incident occur that might make you think that you're going to be, I'd welcome you all to reach out, and we'd be happy to talk a bit more in depth about your specific situation and how we can help you in that sense. In recent developments, though, I wanted to take a moment to address that there is an unfortunate and trend going on in terms of fatalities this year. The Assistant Secretary of MSHA put out a letter just at the end of last week to address this. It was an open letter to the industry. Then that is just discussing the fact that there is this spike, and that's this year we're already at 16 minors having been involved in fatal accidents. Now, that is a big number. If we say that's 4 a month and extrapolate that over the year, we're looking at a 48 fatality year. That's a very high number. We haven't been that high in many years. Additionally, in that, if we break it down, the Assistant Secretary specifically mentions that 13 of those were in the metal, non-metal, and 3 were in coal. Now, we'll talk here in a slide or two just about kind of the differences there in the industries and really how active they are. But nonetheless, this is not a good start to the year. We are going to be seeing a lot of discourse from MSHA. We'll likely be seeing a spike in enforcement in the areas that they trend and just areas where they think there are serious accidents. So we should be prepared for that. But more importantly, we should be, taking a moment and reevaluating our own sites. What are we doing to foster that safety environment, that safety mindset, that safety culture that we've built over the years? And what can we do to really just kind of take everyone back a moment, take a deep breath, and refocus the workforce so that we can stymie this trend before it really gets going? Because MSHA talks a lot about it. This letter, I think it's got a good tone because it's talking about how everyone needs to partner together. But you are all the people that are going to be involved on a daily basis at every mine in the country. MSHA cannot be there, right? They will come and do their mandatory inspections. They will come and do compliance assistance or outreach programs as time and resources allow. But if this is going to be turned around, if this year is going to be kind of stopped in terms of what we have as a spike at this early point in the year, it's going to come down to us or you all as the kind of day-to-day operators of mines around the country. So, in that, this is unfortunately a timely presentation, but not for reasons we want it to be. And hopefully, as we get through the year, we start to see that trend of fatalities slow dramatically. MSHA is putting on what they call Stand Down Save Lives Day on May 17th, where they just want everybody to kind of take a break, have a safety stand down. They say they're going to provide materials on that, but you don't have to wait for MSHA here. You guys obviously control your mine sites, you control the environment there, and you're going to be able to affect change much more so than MSHA ever could at every mine in the country, every mine that you all control. So, unfortunately, it's a topic that is spiking right now, but we need to be aware of it. We need to be active in trying to stop that trend and turn it around and make this a better year moving forward. Now, I will say, last year we had a similar trend. It wasn't quite to this degree, but we had a kind of a spike in the fatalities at the beginning of the year, and that did cool, and it ended up being too many. Any fatality is too many fatalities, but overall, a lower year than the one before. And that's a positive, right? That's always our goal, is that this year will be better than the last. So, we're not at a point of no return by any means, but we do need to be intentional in trying to kind of right the ship in that sense. Just in terms of kind of where we see, this is some data based off of the breakdown of fatalities over the last few years. It's looking at 2020, 2021, 2022, and then this year to date. Both 2020 and 2022 had 29 fatalities that year in the mining industry as a total. You can see that that's a blue line. That's your total line for the industry. 2021 had a higher year. That was 37. So we can see, though, broken down in there, the orange bar is coal and the yellow bar is metal non-metal. So historically, metal non-metal has been higher than coal. We really saw that in 2020, especially with the downturn in the coal industry. And then, coal came back and was a little more of the pie in the last couple of years, but metal non-metal typically outweighs it. This year, we are seeing that metal non-metal is thus far ahead of coal as being the primary driver. And that's what the Assistant Secretary calls out in his letter, 13 versus 3 for a total of 16 this time to date. Is that going to stay the course? No, historically, we would see that there should be kind of more of a partition there, but metal non-metal is typically the side of the industry that has more fatalities than coal. And that's really just kind of a simple reason. And that's math, right? Metal non-metal mines make up by far the large portion of MSHA's regulated community. From just a mine standpoint, we can see that there's, on average, more than 1,000 mines, more than 10,000 mines in metal non-metal than there are in coal. The miners, we have a factor of 4 in terms of more miners in metal non-metal than there are in coal on an annual basis. And this is looking at MSHA's own data from 2020 to 2022. And if we look at the hours worked, MSHA only had data for 2020 and 2021 right now. But again, we see, almost or a little more than 4 times the hours worked. So a lot more miners are involved, a lot more mines, and a lot more hours worked in the metal non-metal industry. That's not trying to make excuses for the metal non-metal industry, but it's just trying to recognize the facts there. We often think of MSHA as a coal-centric regulatory agency, and that's because historically it has been. A lot of their focus is on coal, a lot of their leadership comes from the coal industry, but as I continue to harp on throughout these webinars, year over year, metal non-metal is the primary driver of MSHA's regulated community, and it isn't particularly close. So, the disparity between metal non-metal and coal in terms of fatalities on an annual basis, obviously we'd love to see all those numbers at 0, but it isn't because metal non-metal is inherently unsafe or more lax on safety or more lax in safety procedures or compliance than coal. It has to be considered that there's many more miners working and they're working many more hours than we see in the coal industry. I just think that's an important thing to point out. The letter obviously doesn't get that granular, and it's making good points that we need to have a kind of stop, a reassess, a refocus towards safety. And I support all of that 100%. But, we don't want to demonize the metal non-metal industry and say we're comparing apples to apples, because we aren't when we're comparing metal non-metal to coal, just in terms of the volume and the persons involved. So, again, I'm not trying to make excuses. I'm just trying to put some color into the context, because I feel like that, it points out that there's so many more metal non-metal, but it doesn't give any basis about why maybe that, they don't compare equally. So, that's just wanted to not get lost in that too long. I wanted to bring it up though, because we should be focusing on it. You're likely going to be seeing outreach in terms of MSHA inspectors discussing this. They're going to be discussing the May 17th stand down. This is the type of situation where we typically see MSHA management start making more trips out to the mine, including field office supervisors, maybe even some people from the district, if you're near a district office. So, be prepared for that, but also MSHA is going to do what MSHA does here, right? They're going to provide materials. They're going to try and do outreach. They're going to try and do compliance assistance, but MSHA is an enforcement agency. So when trends start going in this direction, when we start seeing issues with safety in the mining industry, or at least trends that indicate there might be concerns with safety, MSHA regulates, they enforce, and we should be prepared for that. So first, take care of your people. Make sure your people are being safe. Make sure they're appropriately trained. Make sure they have the equipment and the safety practices they need. Make sure they're adhering to our site policies and our site procedures that are intended to protect them. But also then be prepared that we are going to have a more scrutinous eye coming from our regulator until they see this slow down. And hopefully it does. If it does, I'm a firm believer it's not going to be because MSHA has regulated into existence. It is because the industry has taken action, but they will see a spike of enforcement followed by a drop in the serious incidents or the fatalities as evidence that that approach works as well. And, is there some push-pull there? Is there some common ground where it plays into that? Of course there is, right? But the driver is going to be the industry, right? It's going to be the operators and your personnel on the ground. So, take some time, reassess where we can maybe have those toolbox talks, have a meeting, have a stand down, site by site, crew by crew, just to refocus everybody as we, get into the busy months of the summer. I know that it's busy a lot of parts of the country right now, but the northern half of the country, if they aren't already operating, is going to be getting into prime season here soon. And so we, like to see this kind of not see a continued trend as we are. But in terms of that, want to focus now on what happens if we do have a serious accident. What if we do have a fatality on site? There's obligations that we have to adhere to. There are requirements that we must notify MSHA, that we must conduct investigations, and then on top of that, we're going to have MSHA likely conducting investigations. Even if it isn't a fatality, there's a very good chance MSHA will be on site following a serious accident to review it, to follow up on it, to continue to ask questions of us, and possibly issue enforcement. And that's what we're going to talk about the rest of this. So just navigating that, what are our obligations internally as a company, as an operator, and how do those interplay with MSHA? And then how do we best protect ourselves moving forward? The first part of that is reporting, right? In the MSHA world, if you are familiar with this has been on your radar for a while, you won't be surprised. Many people are, though. MSHA requires notification within 15 minutes of an accident, and that is defined by MSHA, which occurs on the mine site and after the operator becomes aware of it, right? Or should have become aware of it. That's not a lot of time. Why do we see this 15-minute rule? This was implemented after some of the major underground coal disasters in the early 2000s because there were significant delays in notifying MSHA, which was significant delays in rallying underground rescue teams. So that is really the primary driver of this 15-minute rule. It is meant to initiate response. But for many, that rallying underground rescue teams from 5 hours away isn't a relevant reason for that. But nonetheless, you are required to adhere to this 15-minute notification. If you're more familiar with the OSHA world, that's probably a crazy requirement to hear, right? I mean, in that we have 8 hours for a fatality, 24 hours for inpatient hospitalization, loss of an eye or amputation, something like that. But in MSHA, an accident, and we'll cover that definition here shortly, is required to notify MSHA within 15 minutes. That obligation falls on the operator of the mine site. Now, we've talked about this many times, but independent contractors, production operators, both are quote unquote operators to MSHA. The obligation falls on both of you. If you have contractors on your site, if there is a serious accident involving a contractor and they don't know to call MSHA in 15 minutes, it is going to be the expectation of the agency that the production operator be making that phone call as soon as they become aware, within 15 minutes of them becoming aware of it. This is always something that I say that companies and contractors should be sorting out prior to work beginning or prior to be engaging in work together at a site. But you need to determine what is your procedure for notifying MSHA in the event of a serious accident, and what are contractors supposed to do? Is it the responsibility of the contractor to notify the agency, or is your site's policy that any serious accident be notified to production operator personnel, whether for notifying MSHA or so that they can rally, on-site emergency response teams, or both? But you need to have that sorted before an incident occurs. If you do have an incident where both sides don't think the other one's calling MSHA and no one's calling MSHA, usually someone, if not both, will be fined by the agency when MSHA gets out there and figures out that you haven't notified them, right? And that's in the death of a mine or an injury or entrapment, which has a reasonable potential to cause death. That fine is going to be, at least at this point this year, $7,133, all the way up to the statutory max of $85,000 and change. So it's not a nothing amount of money. It is not a throwaway. It's not one of those $145 citations after our good faith abatement credit. So, it is something that we have to pay attention to. If there is confusion, MSHA can cite both parties, right? They have dual citation authority. Usually they're going to pick out one of them and say, this is the party that we believe had knowledge of the requirement and should have acted upon it. And oftentimes that can be frustrating because it can be the production operator, even though the contractor had the injury and the contractor didn't report it. Remember, strict liability, you're always responsible for everything on site. But if we have it in writing, in some kind of work agreement or something like that beforehand, that the contractor will notify MSHA, or the contractor will notify us and we will notify MSHA, that helps at least show at MSHA that we contemplated the situation, we had a procedure in place. And then if our contractor didn't follow that procedure, or if we're a contractor and we notified the operator and they didn't contact MSHA and they were supposed to, it gives us a defense in terms of avoiding this kind of penalty that is just, did this happen? Did we not get called in 15 minutes? Yes, then there's a citation, minimum of that $7,000. So be aware of this, be aware of your reporting requirements. It's listed in Part 50, it's 50.10, immediate notification. It provides the 1-800 number that you're supposed to call. Once you know or should know that an accident has occurred, again, there that should know, it means we can't really put our head in the sand and say, well, we weren't aware of it, or, no one was called. If it is occurring on our mine site, unless it's an area where there's no other traffic, we should know what's going on and we should be prepared to contact MSHA. MSHA defines accident as death of an individual at a mine, injury at a mine which has a reasonable potential to cause death, entrapment that has a reasonable potential to cause death, or any of these other elements listed in the definition of Part 50 under accident. We should be reviewing these, right? We should figure out which one of these apply to our operations. A lot of these are specific to underground mining. Some of them are specific to hazards, which we usually only see in underground coal. If that is not our operation, we probably don't have to pay that much attention to that kind of definition of accident. We probably don't need to train our people to be aware of it, but we should be looking at these and figuring out what triggers are going to satisfy the definition of an accident and which of those triggers are likely to be happening on our site. Because if we run 24/7, someone's always going to be have to be available to make this determination, and at least know that they have to ratchet it up the chain of command to determine, do we need to call? So we need to be prepared that someone's going to have to make a call. They're going to have to make that call very quickly, or they're at least going to have to know who to contact, who's familiar with the definition, to determine if a situation is a 15-minute rule. Now, MSHA says, when in doubt, contact us. There is merit to that, because you protect yourself from that possible non-compliance with the 15-minute reporting regulation. But the other side of that is, you don't want to over-report, because one, if you're over-reporting, it's going to draw immediate interest from the agency, right? They are going to come out. We want to make sure that we're reporting what we need to report. And if it is not satisfying the definition, we don't need to. We can take that back. We can do our internal investigation. We can notify MSHA if there's a change. If someone has a serious injury, but we don't think it's likely, has a reasonable potential to cause death, or there hasn't been a death, we might not necessarily have to contact MSHA. But if their condition worsens after the fact, then we will still. If someone gets injured at the mine and then later does die because of the injury sustained, that is going to still trigger our reporting requirement to MSHA. So we need to keep that in mind as well as we go through this. It doesn't necessarily end just when you get off the mine site. If things continue to progress, you can still be triggered to contact them. In terms of that, you're going to call, you're going to give some background information to that 1-800 line. That is not an MSHA personnel, right? That is a call line who is managed. They have a form that they check down that is going to ask for contact information, the location, the type of injury, the status of the injured parties, and then the district is going to call you back. Usually it's going to be someone who's in district management, either the district manager, one of the assistant district managers, or someone on that kind of level who is managing the call phone, especially if it's after hours. At that point, they are going to ask you probably a lot of the same questions that you were asked by the hotline. They are going to have that report. They're going to verify that information again. And the big thing they're going to be asking is the status of the injured party. If it is a fatality, you can pretty much expect at that point in time, they're going to be issuing you a verbal 103J order that will eventually become your written 103K once someone gets out there. They're going to immediately dispatch inspectors. Whoever is closest will show up to secure the scene. And then the investigation team into the fatality is going to show up probably in that day or the next day. They will come from somewhere else in the district. Usually, it's rare, but sometimes they come from out of district, especially if it is a particularly serious disaster type situation. But usually it's just going to be from someone in another field office in the district who's going to come in and be the investigators into that fatality. If it isn't fatality, but it is a serious injury and maybe someone's at the hospital following it and we don't know their status, or we think it is something that has a reasonable potential to cause death, MSHA, depending on the circumstances, may still issue that J order. They may still immediately dispatch inspectors, but maybe it's not going to be investigators into the fatality from another part of the district. It might just be nearby inspectors. And they're probably going to ask you to provide regular updates on the status of either personnel or rescue efforts or something along those lines. Now, one thing to talk about here is if MSHA is asking for updates, provide updates at the rate at which MSHA is asking for them. If they are asking for updates every 10 minutes, and it's not a situation that's changing every 10 minutes, obviously we need to talk about that and let them know that. One area where this sometimes becomes an issue is if we have people in the hospital and then, possibly the family arrives and we're no longer being provided updates regularly. You need to just tell MSHA that, and they'll probably be asking for contact information for the next of kin or the family at that point in time so they can try and get them directly. But just make sure you're telling them that, because if you go dark on MSHA because you don't have anything to tell them, but they're expecting updates, they're going to keep seeking them. They're not going to be satisfied that, oh, hey, we just don't have anything to tell you. Let them know that. You can work on a new strategy for updating them as you go, and you can at least let them know that you're a little bit more outside the loop than you were. You are probably also going to hear, depending on the scope. MSHA might ask that all operations stop or operations in a certain area until they get there and evaluate it. That is the intent of the 103J order, right? It is to protect the mine until MSHA gets there, to evaluate whether or not it's safe to continue operation and what is the hazards and how do we correct those hazards, abate those hazards. But, you are gonna likely hear some of those key terms as you go. Really though, if an accident's happening, we should already be barricading it off. And that's what we'll talk about here in this next section, and preparing for our own internal investigation without needing to be prompted by MSHA. That is another thing though, as we go through this, when you're talking with MSHA, and especially when they get there and start looking at writing that 103K, that 103K is a shutdown order. It is going to limit operations everywhere that it touches, the scope of that order, until it's lifted by MSHA or they modify it to allow us to resume operations. Have real conversations with MSHA about the scope of the K order. Don't let a K order be over the entire mine, unless it really is the scope of the investigation, the scope of the hazards, et cetera. We want to try and narrow that in. You can continue operating in areas outside the K. If someone got caught in a moving machine part in a conveyor belt, that doesn't mean the entire mine has to shut down. We probably need to figure out what was going on in that specific conveyor or what we're following, if it applies to elsewhere. But it doesn't mean that, you can't load trucks and have trucks leaving the mine site, unless you can't do so safely. So pay attention to that, and try and talk about that with MSHA either before it gets in writing discussing the scope, or immediately when you are handed the K order. Look at what the scope is. I've had MSHA issue them for the entire mine, and then we've had to be like, we need to get that amended because we can't do anything on here other than try and maintain the operation from becoming more unsafe until you modify the K. So be prepared for that. A new trend as well with K orders is MSHA, if we do have a fatality, they are keeping them in place until the final report is issued by the agency. Now, this is a new development. I've only really seen it in the last year or so. Historically, when we have a K order, we've been able to work through having them listed, entirely before that report comes out. Those reports can take upwards of a year or more. So, we are not seeing that, but what we should be seeing though is that MSHA is continually walking them back and modifying them, allowing us to essentially get back to operations. And in most cases, full operations over the full mine and the ones I've been working with them on, but with some conditions, and usually those conditions are met in order to begin operations under the modification, but that K order is still in place. So you have to be careful of that, because if you need to do something beyond the scope of that modification, you need to get a new modification. And in that process, I found that the districts and the investigators have been willing to modify them and work with operators on that, but it's strange that we're seeing the K orders remain in effect for that long. Usually we had those historically. We've had those lifted entirely within, a few weeks to a few months from the date of the incident, depending on the severity of the situation. So, that's a change in policy. We're still not seeing people kind of kept out of operating them as they want to, but they are being kept from having that lifted. So you just got to work with MSHA more so on modifying that and getting it modified to the place where you can get back to operating your mine. So that's in terms of reporting. In terms of what are we doing on site, that's probably the more practical, right? Things that we know are going to be expected of us, not only by MSHA, but frankly, it should be our own policies, right? Immediately you're roping or barricading off the area where the incident occurred until, we can be satisfied either with our own internal investigation, or MSHA completes their investigation and gives permission to open the area back up. This is often one of the challenging elements when we have a situation where it doesn't seem nearly as severe at the time of injury, but maybe the person gets to the hospital and we realized they don't just have a broken arm, but they have a severe head injury as well, and there are actual concerns that it could result in death. At that point, we should have already barricaded this off until we figured out what happened, and not allowed people just to get into that area and keep working and pull things out. In that situation, it's a little difficult because MSHA is going to expect you locked it down immediately, and you have an obligation to preserve the scene. And if we haven't done that, we can face an enforcement on that front. But also, we should be doing this ourselves. We're going to have to do our own internal investigation, and we need to make sure that the scene is preserved. If it is in an area and we're not under K order that is high traffic, maybe we can't close it off for extended periods of time, we need to move quickly to first barricade it, shut down the area as much as possible for time for us to evaluate it closely, capture plenty of photos, plenty of videos as needed of the area to show what it was like at the time the injury occurred or the accident occurred, and really capture that moment so that we can effectively complete our own investigation. And then if there are any developments where MSHA is saying they need to see what it was like at that time, we can also provide that information. But we should, be looking at it. What do we need to do here to protect people from further injury? That's what part of what MSHA is going to be doing, and we should also be doing it before them. We don't need to wait for them to get there in order to do that. Make sure everyone on site, this should be part of training long before we get to the point in time when an accident's occurring, but make sure that all people on site know if there is an area that's barricaded or an area behind rope or an accident scene, that is a no-go area, right? That should be monitored by safety or by someone in management or someone who is there to secure it if we're worried that people are going to enter it. Anything within that area needs to remain. That means equipment. We can't go pulling, trucks or loaders or anything out of there. I mean, even the equipment that was involved in the accident, be it hand tools or some smaller equipment, we need to leave that there until we can finish an investigation into that. We can't have that going. And if we have a K order or a J order in effect, it is, technically, MSHA would call that altering the accident scene, even if there's no intent to alter it. It's purely someone just came to get that loader so that they could use it in another area. We need to get permission there from the agency to move something in the face of a K. If we have an area where maybe we have bad weather coming in, we can't control that. We can't control how that's going to affect the site. Try and take enough photographs and collect enough information before that happens so that you can effectively have an in-the-moment capture of the scene before it changes too much. This is just to say that there is an obligation that MSHA has that you preserve the scene. The only time this really becomes too much of an issue is when maybe we don't know that the scene is going to be subject to an MSHA investigation until we've already changed it, and be that because we didn't realize the severity of the injury or elsewise. So that's what we need to make sure we're documenting in terms of our own internal. You do have some caveats here. It says that no operator might alter an accident scene or an accident-related area until completion of all investigations pertaining to the accident, except to the extent necessary to rescue or recover an individual, prevent or eliminate an imminent danger, or prevent destruction of mining equipment. Now, I will say, you still want to be careful in how you're acting. You're going to want to document if that's the case. If you're doing rescue operations, you're going to need to probably want to be telling MSHA about that, or recovery. A lot of times they're already on site when that's going on. If you are trying to prevent the destruction of mining equipment, again, have we been in contact with MSHA already, or are we actively in contact with them? We want to tell them about that and just make them aware. So there's no question that we're trying to hide anything, right? We are trying to prevent destruction of equipment or save individuals or perform a recovery operation. It's really, most of the issues I see with this could have been avoided if we had kind of open dialogue with the agency. They typically are reasonable in response here. And if they're not, we'll keep working to find someone who is willing to have a reasonable discussion about our position and what we need to do. But usually when you have issues here that result in enforcement, it's because MSHA finds out someone came in and just moved something, you know, because they wanted it or because they were trying to clean up the site or something like that. And, you know, they will unfortunately go to the assumption that we were trying to hide something. And that's what we want to avoid, because, you know, if they think we're trying to hide something, it's kind of hard to prove a negative. We weren't. But we will have to be fighting that opinion, or that, at least that impression of MSHA, for a good while. Additionally, we have an obligation not only just to do our own internal investigation, you know, which most companies I work with always have a policy about that, but we're also obligated to do one from MSHA, right? We will be obligated to do an investigation for each accident and each occupational injury at the mine. So that's not just an immediately reportable accident. That's anything that we're filling out a 7001 form for. It specifically outlines 9 items that have to be part of this. Now, you know, my recommendation is that you don't use a root cause investigation file that's 43 pages long, or 12 sides, or 5 Ys, which is talking about hypothetical areas where it could have been the reason, as your 50.11 investigation, right? This is an MSHA required document. I suggest that everyone make and have an MSHA required 50.11 investigation form. And that when it is requested by the agency, which it will be in a serious accident situation, you provide them that. If they ask for any other investigation, we will wrestle with whether or not it was done under privilege, whether or not it was done in a way that it is discoverable, or that we need to provide it, or want to provide it, or have to provide it. But we will weigh those decisions. But if you have this form that is a 50.11 investigation form, you have that separate form, you can provide that and you're in compliance with this set part of the act. So consider that. You can do your root cause, you can do your 5 Ys, your 10 Ys, whatever it might be. But I would say you have a form that includes this information. And it's largely the information that is already on that 7001 that we're going to have to submit within 10 days of the accident occurring. And that applies to a serious accident, a fatality, or just an occupational injury, or somewhere where medical treatment was given instead of first aid. So be aware of that. If we are a small operator with fewer than 20 miners, we can use that 7001 as our 50.11. I still think it shouldn't be too hard though to, you know, have an appendix file, a 50.11 page. It can be really just 1 page or maybe 2 pages if you're looking at the information that are required here, and then identify the information outlined here so that you're able to provide it to MSHA. In terms of more robust incident reporting or internal investigations, I mean, this is obviously crucial. I'm not telling us not to do these. I'm not recommending that we make light of them, but we need to be careful when we're doing that. Unless you are working with counsel immediately and we are directing you to do that or complete that investigation at our direction, it's being folded into our attorney-client communications, my attorney work product, it is going to be discoverable. If we are just doing one because our safety person showed up and immediately got into it with no discussion from legal counsel, it's going to be a discoverable file. It may not be discoverable in that MSHA asks for it during their investigation, although they usually do if we have something complete. But if we're challenging citations later on, I'm sure that MSHA discovery is going to say any internal investigations into the incident. And if they're not protected by privilege, we're going to have to turn those over. So, you know, we should avoid jumping to conclusions. And that includes in our notes, in emails, in text messages about why the accident occurred. We should focus on identifying facts, identifying, you know, recognize contributing factors and causes. And then later on, you know, we can go through the process of determining what that root cause and why we think it was. But just remember, the internal investigation records rarely are limited to just your final product. It's all the communications that went into that. It's text messages, it's emails, it is going to be written statements. So, on that though, I just want to be clear with everybody. If in any kind of serious accident or any kind of fatality investigation, there's likely to be a lot of back and forth, a lot of communication internally, externally. What I will say is, though, just understand and beware that when MSHA comes in, or it doesn't even have to be MSHA, a third party later on is asking for electronic communication, that isn't just email. That is going to include your text messages. And it can be text messages that are about the injury, and it can be that day, that week, that month, or 10 months later. If you're talking about what happened with somebody else, it can still be discoverable. So I know we all love to text message. I know it's a really convenient way to do things, but keep that in mind, because text messages are going to be discoverable. We are going to have to capture those. We're going to have to be prepared to produce them. And someone's going to have to read through hundreds, if not thousands, of texts of yours in order to determine if they are responsive to any request or not, or if they're talking about this. Or so, my recommendation is, to the extent possible, you have phone calls, you have in-person meetings about this information. When we're sending written files or written communication, we try to make it email. We try to notify people by email, try to keep it on email, because it's a lot cleaner and it's a lot easier for us to manage later on. It's a lot less invasive for us to produce if we have to, and to review if we have to. Because text messages, that just gets very invasive, very kind of personal quickly, and they can swing, but we have to still review all those, and they might be producible based off who you're talking to and what you're talking about. Another area where we always see MSHA start asking for things, especially if they're coming out a day or two later because maybe the situation turned more serious or the condition of the person worsened, is for written employee statements. We obviously are going to collect those all the time. If we are engaging with legal counsel, we have legal counsel, we're going to do this investigation at their direction so that it's under privilege. We want to make sure that we are collecting those written statement under that privilege so that they remain within. If not, they're going to be discoverable by MSHA. They are going to be producible by MSHA, and MSHA is always going to ask for those when they get on site. If we are reducing witness statements, we are producing those, we are reducing them to writing. Just know that if we sign something and we date it with MSHA, they consider that almost the same as a sworn statement, right? If I write Nick Scala's statement at the top and I just print it and I write my statement, but I don't sign or date it, they do look at it differently. It's a contemporaneous, recollection or recitation of what we saw, but it's just viewed differently, and it doesn't make a lot of sense, right? We're not signing it in front of a notary. We're not testifying that it was a sworn statement or anything like that. It is not a declaration or an affidavit, but the act of signing at the bottom, just MSHA takes that to mean this is it. This is my statement about it. And if we remember something else later on, it can be difficult to get that information in there. MSHA doesn't want to accept it because, oh, well, you did this at the time of. So, obviously we want to collect those statements. They're very important to us figuring out what happened, but just remember, we want to be careful with, signing them and dating them. We want to make sure that we are just kind of capturing that. We want people to be sure that they're not pressured into doing it before they're ready, while also weighing that against letting them wait too long and their recollection gets clouded because they're thinking about something constantly. So, keep these in mind. It's a lot of moving parts. If we are going to have to engage experts, maybe because it's ground control or it's a moving machine part or a piece of equipment that malfunctioned, again, our recommendation is that you're working with counsel on that, because then you can retain that expert through counsel, and their reports can be done under privilege, can fall into that protected category. So we can evaluate what we have before having to turn it over to, an adverse third party, whether that's MSHA or that's a plaintiff's lawyer down the line. So these are instances where we want to move very quickly, obviously, but we also want to make sure we're being deliberate in our steps so that we're not creating any issues for ourselves down the line. Maybe because we were jumping in too quickly or we didn't have an established procedure or policy. If you are unfamiliar with how to do internal investigations, if you don't have that expertise or that experience, try and get some more education about your company's internal expectations and policies from maybe a more senior member. Or if you need to talk, at more depth with someone else, let us know and we'll be happy to give you some more information about what we see as the process, or engage with someone at the time. But it is going to be important that you are prepared there. So in addition to kind of talking about our own internal investigations, MSHA is going to be doing one if it is a very serious injury, and most certainly if it's going to be a fatality. And so we have to prepare for that and what it's going to look like. It is likely not going to be the same as an inspection. And I use those terms intentionally, inspection versus an investigation. An inspection, right, is our regular safety and health inspections. Our EO1s happens 2 times a year if we're above ground, 4 times a year if we're under. An investigation is more targeted, whether it's a complaint investigation or it is a serious accident investigation or a fatality investigation. And MSHA's approach is different. If they're coming out because you had a fatality or you had a very serious accident where one or more persons are very seriously injured, it is going to be very heavily involved in interviews. They are going to want to interview any person on site, and even maybe some of those who were on site. Maybe they were off, but they worked the same job on another shift. And they might interview them a couple times. This can obviously be difficult in the instance where we're talking about a fatality. People don't want to talk about it. People don't want to talk about it multiple times. So, we have to balance that by getting information for ourselves, getting information for MSHA, with also, being respectful of each person's, needs and concerns as we go through it. If we think people are struggling, MSHA will usually be respectful of them needing some additional time or something like that. And they should be. If we don't feel like they are, if we feel they're trying to force the matter, they better have a good reason for that. And we will push back and we'll contact management as needed to kind of protect the well-being of our people. But we need to be prepared, and our people need to be prepared. That's going to happen. Additionally, we are going to get document requests. They are going to want to see every mandatory record that may be applicable. Mandatory records are going to include training for all minors. Task training specifically is always going to be scrutinized. Usually when we see a serious accident or fatality, we also see a task training citation in the end, if there is enforcement. And that's because there's an adequacy requirement there, right? It has to be adequate. And if there's an accident or a serious injury, even if we have task training on it, a lot of times MSHA is going to find it wasn't adequate because an accident occurred. It's a bit of a self-fulfilling prophecy there, but we see that frequently. If we don't have task training for that particular task that the person was completing at the time of injury, we're likely going to get a citation for just not having it, not that it wasn't adequate. MSHA is going to be looking at pre-shift exams on mobile equipment. They're going to be demanding that we give them all of our workplace exams. Remember, we have to keep those for a year from the date they are created. Site-specific records, this is especially true if we're going to see contractors involved or visitors of any kind. And then if we have a fatality, we will get a Part 50 audit of our accident injury reporting documents. And if it is a serious accident, we likely are still going to get that. It's not necessarily going to be immediately after during the accident investigation, but it will be at some point after that. So we're going to get these. We're going to have to be prepared for it. They're going to ask for Part 50 documents as part of their accident investigation, but we'll also then have a nice in-depth comprehensive Part 50 review. If we know MSHA is coming out, you can just start gathering training documents, your training plan, and your workplace exams, because it's going to be requested. And we know that it's going to be requested. I'm not saying just hand it to MSHA when they get there, have them ask for it so you know exactly what they're asking for, but it is going to be requested. For witness interviews, look, everyone's going to be asked to speak with MSHA, whether you're management or not. Whether you're management or not, you have the same minors' rights as anyone else. You know, and everyone needs to be aware of these. We should be covering these annually during annual refresher training and a new minor training. That's required. But also at the beginning of an investigation, we can let everyone know here, you have the right to speak with MSHA, either at their initiation or at your own. You have the right to speak alone, but you know, you also have the right to speak with MSHA, or I'm sorry, to decline to speak with MSHA. The people don't have to. If they don't want to, if they're not ready to, all those different things, they can decline the interview. They are in control of that situation. They don't have to do it alone. They can have anyone they want present, whether that's a coworker, someone from the union, a friend, a manager, an attorney. You know, they can have anyone they want with them when talking with MSHA. MSHA cannot require them to speak or participate or give them a written statement. They can't require them to do that alone. That's not a right that MSHA has. They can't coerce or threaten someone into sitting down with them because they want to and the person doesn't. You know, there are limits. People just need to be prepared to voice their opinion, right? If they want someone in the room, they need to be able to tell MSHA, I want this person in the room. If they want to decline the interview, they need to be prepared to tell MSHA, we decline. You know, the declining as well, especially when it's, you know, rank and file minors, non-management personnel, you know, we can't walk in a room and tell MSHA, you know, these 4 people decline to speak with you. They're going to want to hear it from them. So those people need to be prepared to tell them that. And that's fine. But that's what I always tell people. Whatever you want, you're in control, but you have to be prepared to tell MSHA what that is. But review these rights with them before MSHA gets out there, because these interviews are going to be a big part. So a couple questions that we just kind of have been, if MSHA is requesting documents, it's likely going to be documents that are required, right? The training records, the training plan. But what if they're asking for things like production records or different types of inspections, or, you know, they're not required? This is kind of a push-pull. We have to be prepared to push back if we don't want to give it or we can't give it for other reasons. We should never be giving MSHA anything that's under privilege without, you know, consulting with whoever has that privilege, whatever attorney that is. But also, you know, get all these requests from MSHA in writing. We can't delay. We don't want to impede them and, you know, not provide them materials in a timely fashion, but we also don't need to give it to them immediately, you know, outside of the things that we do have to give immediately, like training records. You know, we can take that back, review it. So request that MSHA give you a document request in writing. If they're rattling off things they want, you know, try and write them down, try and capture that, and then tell them at the end, hey, just send me that in email so I have it, make sure I'm not overlooking things. You can review that internally, you can collect everything, you can review it with counsel if you need to determine if we got to push back, or if MSHA is overstepping, or if it's just not a document we have, but they're expecting it. So can MSHA compel documents or require we produce documents not required under the Mine Act? Yes, they can. They don't have subpoena authority like OSHA does, but they do have some pretty strong provisions of the Act, Section 103H in particular, that allows them to get what they need in order to complete their investigation. But, you know, it has to be kind of a back and forth process. There is room to discuss what they're asking for. There is room to discuss whether or not we have it, or it's really unnecessary given the scope. But you need to get that in writing. You need to make sure that you're compiling everything at once. Don't make sure one person is going to be the point contact for gathering information, getting those requests from MSHA and producing that to MSHA, so we don't have a bunch of people sending different things. And then make your own file, right? Have a file that's electronic or physical that is copies of every single thing that's been provided. and, label them as information that's been provided to MSHA, so that later on you can, provide it internally or review it or have it ready for an attorney that gets brought on. But make sure that we're not just kind of sending materials out as they come in, as the requests come in, that we're not failing to control them. We want to make sure that what can be a pretty chaotic environment is as controlled as possible. And these document requests are often one where, inspectors are just walking around like, well, hey, I want this now and I want that now. Tell them to reduce it to writing, get that to me. I'll be sure to collect everything and, let you know if I have any questions. But we're going to have to comply in some way. We're going to have to decide if we're going to refuse to comply and why and what our basis is. But it's hard to do that if we don't know exactly what they're looking for. So if they provide it in writing, we know the documents they're seeking and we can respond in kind. Can MSHA require you to provide records that are maintained longer than required by regulation or not required at all? We kind of hit that not required at all already. I will say, know your company's requirements on maintaining documents. Compare them to how they align with MSHA's. Your company needs to make a decision if you want to keep workplace exams for 24 months or 12. I can tell you that MSHA requires them for 12 months after the date they're created. And I can also tell you, if we have 24 months of workplace exams and MSHA finds out about that and asks for all 24 months for a certain area, we're going to have a hard time refusing to provide those because they're readily available and we've maintained them. Pre-shift inspection forms, we make these. I suggest that we make them so that we can prove to MSHA that we did it. But remember, if there's a defect listed on there, we have to keep that report until the repair is completed and the defect is corrected. After that, we can toss it in the trash. We don't need to maintain it for any kind of obligation with MSHA. It's that responsibility or obligation to maintain that ends when the repair is implemented. But if we are keeping these, and a lot of companies do because they need them for maintenance, maybe their hours and their fuel usage are on them as well. Have a policy or a procedure in place to put your corrective action on there, your corrective action date, and what was done, to ensure that we don't have a bunch of records sitting in a file that say, here's hazards that were on our equipment, but we never corrected them, or we cannot prove it without, in writing, I should say. We cannot have concrete evidence to say we looked at it on this day and this is what we did. I had a client one time, we were working through a number of different hazard complaint investigations, and there was no serious injury, there was no fatality, but MSHA found a drawer full of pre-shift inspection forms. And we had not done exactly what I was talking about. Put on there that areas were, or items were checked out, put them on that they're repaired, and our mechanic who had left, we found out wasn't maintaining those records either. So, we ended up getting 104Ds from the inspector because they said we had patterns of adverse or defective conditions on equipment, and we could not prove that we were really paying attention to them or fixing them, or at least checking each one of them out. Our stance firmly was that we did each of those things, but we didn't have the documentation there. So if we were doing each one of those and we were fixing them and we were checking them out and making sure it was or wasn't an issue, then we could have thrown those in the trash. We didn't have to keep them from MSHA's stance, from MSHA's record keeping obligations. But that company in particular in this instance didn't have their own policy on it. They really didn't think anything of it until it was too late. I can tell you now, they document when they repair something, they document when they evaluate something and see it needs no repair, and then they get rid of the pre-shift exam. So know what your company requirements are, evaluate that with what you're going to be expected, that in these situations where MSHA's on site for a serious accident or fatality, they're going to be casting a wide net. The same is this is not required at all, but it kind of fits in to these, but your internal audits or assessment records, if you're one of those companies that is doing your own internal assessments, or maybe you're having groups from another mine come to this mine and do an audit, that's great. those are good policies. Those are good things to improve safety, but make sure you are documenting that you have corrected every item listed in there. You do not want to have an internal audit or assessment report or record sitting around from 2020 that shows that 4 areas where needed guarding and someone got injured on that later. If we went back and we corrected it, but the person took the guard off or it got damaged again, we at least would have that record to prove we addressed it when it was brought to our attention previously. But if we don't have that, we don't have the corrective action along with that report or that record, it's going to be used as knowledge that this condition existed previously and we should have done better. So things to think about, they come up, we need to be careful, but this is why we want everything in writing so you can evaluate that. So someone can be saying, well, yes, but find our corrective action form to go with it. Things that we want to look at in terms of those questions. And then lastly, can MSHA issue violations and orders for violations or non-compliance they find in past records? Yes, they can. It's uncommon. Usually though, what happens is it's not issued a separate citation for that, but that information is used to issue a new citation with higher negligence. Maybe it's now a 104D as opposed to a 104A because they're saying that you are on prior notice that greater care was required in this particular area. So these are important things that we have to consider. It's a high stress situation, and a lot of times we're just trying to get through it and make the MSHA part go as quick and as smooth as possible, but we have to consider all these different factors when we're responding to MSHA requests. We're rounding out here, so just some takeaways. Make sure you're prepared and educated to make quick determinations on whether or not something's immediately reportable to MSHA, and make sure you have people at each site that are either trained to make that determination themselves or know exactly who to contact quickly in your organization to help them make that. And then also make sure they're prepared to contact MSHA if they have to. If you're going to contact MSHA in a 15-minute, just be prepared that they're probably going to come out, even if it's not for a full accident or serious investigation or a fatality investigation. They're probably going to come out and just check things out and do a spot inspection at some point in time. So make sure your documents are organized. For your own purposes, speak with witnesses, prepare them that they might be interviewed in an MSHA investigation, preserve your accident scene while you do your own investigation. And then especially if you're under a J order and eventually a K order from the agency, you need to make sure to do that. Maybe I'm a bit partial on this point, but the earlier you get outside counsel involved, the better. We can help you conduct an investigation. We can help represent you with MSHA when they're on site. If you have a fatality situation, I tell my clients, I hope you never have to make this phone call, but I don't care what kind of time of day, night, weekend it is. I hope I'm a call within that 15 minutes or at minute 16. So that way we can start preparing to do our own investigation. We can start bringing things under privilege. We can start also helping you just navigate what is going to come and, how that we are going to best manage that investigation and cooperate with MSHA while they're doing theirs, because it's going to happen. Pay attention to your orders from MSHA, whether this is the scope of a 103K or its termination or abatement requirements on citations they're issuing and requiring you to fix in order to get back to work. If they are overly broad or burdensome, start having those discussions with the inspector, then their supervisor or the special investigator, whatever it might be. Engage in those talks earlier rather than later. And then if you are going to have MSHA conducting investigation, ask for those requests in writing, like we've just been talking about. Maintain a separate file that is a carbon copy of everything you provided to them, electronic or physical copies. If it is physical copies, put them upload them, scan them, do something so you can preserve them electronically and you're not relying on a file that goes missing or gets coffee spilled all over it or something like that later on for future reference or in defense and for potential litigation moving forward. So that is our discussion today. You know, I'll just reiterate. I hope this is something that none of you are ever dealing with, a serious incident or a fatality. But you know, in the event they do occur, you know, it's best to be prepared and at least have an idea what we're going to be dealing with. Thanks for joining us again today. Our next one's going to be next month. We're going to look at MSHA and OSHA jurisdiction. So where do we see a line between our mining ops and our non-MSHA operations? Or maybe, you know, what kind of operations are specifically going to be under MSHA or OSHA, where we can see some delineation. So that should be a good discussion. I usually get some good questions, especially for those companies of you who have operations on both sides of the line. So welcome you to join us there if you have the time. We'd love to have you. As always, check out our blogs as you go and try to stay up on any other topics that we're covering, whether it's OSHA or you're on the employment side as well. Questions there. If we can help you out, you see something there of interest, let us know. And then lastly, if you got any questions, we are happy to take them. Go ahead and shoot them in the chat. We're going to take just a quick break to see what's there and be back at you. But if you don't want to put it in the chat, all my contact information is up on the screen right now. Feel free to call me or shoot me an email at any point in time. All right, we don't seem to have any questions pending in the chat. If they are, again, I'll just reiterate, give me a call or shoot me an email. I'm happy to talk to you all. And you guys have a good, safe day, and we'll be talking to you again here in a month. Bye.